think the other point that's important to flag is the pushback that we will see from the legacy who are not a fan of innovation because innovation is a challenge to the regulatory moat that they use to protect their market share. And so, we're talking about the CFTC's orders related to Kalshi and Coinbase, but the CME, the Chicago Mercantile Exchange, which among friends I will say acts something like a monopolist in the derivatives markets. It has an extraordinary amount of market share and protects it not by coming up with a better product for its consumers, but by trying to box out any disruptive innovation that might take away its market share, has already filed a lawsuit against the CFTC challenging the determination that perps are futures that are allowed to trade on registered exchanges. So it's not just getting the regulators comfortable and having them do the very hard work of figuring out what do regulations look like that expand access to more of these types of products and in more types of venues using different types of technology. It's also pushing back against those who are going to say, we don't want to see this in the United States because it's a threat to our business model.
And where do you think, if you have an opinion, that the CFTC kind of nets out against CME's, you know, regulatory pursuits?
First, I'll say I think it is quite sad and disappointing that CME decided to take this approach. If you look at what the CFTC did, they authorized any DCM that meets the right criteria, including the CME, to offer these products. So if the CME wanted to compete in an open and fair and free market, they could just list these products as well. And what they've decided to do instead of competing in the free market is to run to court and say they need a judge to protect them from competition. And this is, I think, the first reason why the CFTC is very likely to prevail in litigation against the CME. There is this concept of competitor standing. There are limited cases in which a plaintiff can bring a lawsuit that says that there is some action by an agency that results in increased competition, and they can file a lawsuit on that basis. But often, and according to a lot of case law, you can't bring a lawsuit just because there is some action. That means you are going to have a harder time competing against others who are offering an honest and well-regulated product in the market. And so I think the CFTC has a really strong case against the CME just based on standing. I don't know that the CME has the standing to bring this challenge. But then also on the substantive point, the CME makes this argument that perps should be treated as swaps rather than as futures, which would mean that they cannot be listed on a registered exchange. And I think they just have the wrong perspective as a matter of law. I think it's clear if you read the CFTC's orders, they did a lot of really excellent work to explain why a perp is properly treated as a future. A futures contract in general is a standardized contract that trades on an exchange. It's the type of contract that is fungible. So, any one contract is the same as any other. It's a contract that can be offset by taking an opposite position. And perps have, all of these sort of hallmark characteristics of a future, not a swap. And I think the CME's arguments why perp ought to be treated as a swap sort of betray the fact that they are just trying to get an advantage through the courts over their competition rather than having a bona fide view as a matter of law. So look, we'll see what happens in court. These types of litigation, always really hard to predict. It all comes down to what one judge thinks and then what happens in the appeals process.